Hey, everybody. Welcome to Thursday night. John Skiba here with the Consumer Warrior YouTube channel and doing our live stream we do each and every Thursday where we talk about all things debt related, whether it's credit cards, medical bills, personal loans, mortgage, car loans, whatever kind of debt you're dealing with, we can handle it. So again, my name is John. I'm an attorney in the state of Arizona, and I do bankruptcy, consumer bankruptcy work, as well as a big focus of my practice is dealing with people who are getting sued by junk debt buyers like Portfolio Recovery, Midland Funding, LVNV, all those kind of horrible characters there. And the whole reason behind the channel here and why I do this live Q&A each week is because I have found that if you have a plan, if you have even just a little bit of knowledge about the process, it can alleviate a lot of stress, help you navigate a way going forward, and not be so stressed out about all this stuff and get it behind you once and for all. So before we get started, I want to thank our sponsors of our live stream each and every week, Solo Suit. You'll see a link there in the chat section you can click on to learn a little bit more about what it is that they do and what they offer. They have been a great sponsor of the show for quite a while. What they do is they offer different programs. It's really kind of a digital products that they offer in helping to respond to debt collection lawsuits. They have a really slick debt settlement program that can help you to settle the debts without even having to talk to the creditors directly. I know that can be really intimidating to do at times. So if you're representing yourself and you need some additional assistance, it's just one of these other tools in the tool bag. That's what I say. That's what I'm here to help people with, is to find these different tools, understand some of the things you can do to help yourself. If you're in the state of Arizona and you need a lawyer, you need me to help you out, whether it's bankruptcy or dealing with wage garnishment or debt collection lawsuits, my number there is along the bottom. There's also a link in the description where you can set up an appointment. You'll talk with me directly. People always ask me in the consultations, they're like, is it you? Are you going to handle the case? Yeah, there's no one else. It's just me here, me and my great staff that helps me out each and every day. But we'll be able to help you out if you're in the state of Arizona. I'm only licensed here, which goes to my weekly disclaimer that I am licensed in Arizona, but nowhere else. So I can't give legal advice about other states. I don't know the laws in other states. There's some things that are similar from state to state, but just so you're aware, this isn't legal advice. This is just some guy talking on YouTube. So take it for what it is worth. So how we like to do this each and every week is if you have a question, put it in the chat section or the comments on Facebook. I'll put it up on the screen and we can discuss it and I can point you in what's hopefully the right direction. Before I jump into the questions, something I wanted to just touch on. So I'm recording this, what is the October 24th? We're about less than 2 weeks out from the presidential election. I get a lot of questions from people, just friends and family, but also a lot of people who are calling my office here in Arizona to talk about, how the presidential election is going to change. Some people are, they're delaying decisions as it relates to bankruptcy, student loans, all that kind of stuff, depending on the outcome of the election. My typical response is, look, I've been doing this. Actually, I just looked on the calendar today, October 24th. Is 21 years ago today, I was sworn in as an attorney here in Arizona. So officially 21 years I've been doing this, which is crazy. That two decades. It seems like yesterday that I was just in law school. But so, for 21 years I've been doing this. All, the both political parties have been in power during that time period. I don't see a big difference. I mean, just to be frank with you, I don't see a big difference in how it relates to debt collection, bankruptcy. The bankruptcy numbers go up and down. Bankruptcy is hard to predict. That they predicted with COVID, we were going to see, the biggest wave of bankruptcies that this country has ever seen. They haven't, and it hasn't happened since that time. So I would just say, Dave Ramsey talks about that there's the most important decisions are the ones that happen in your house, not the White House. I tend to agree with that. Make a plan, decide really what it is you're trying to accomplish, what you need to do, and then make go forward from there. So with that being said, let's go ahead and jump into the questions. Now, Rob was here nice and early. Rob said, good evening. Good evening, Rob. There was an oral hearing last Friday for the plaintiff's motion for summary judgment, and they didn't file or do anything. So instead of October 18th being the trial date, it was changed to an oral hearing. And since they did nothing, we have another trial date of November 15th. It sounds like you're getting kind of Mickey Moused around by the court a bit here. They're giving the creditor a lot of leeway. If they didn't show up, if they weren't prepared, they should have dismissed. I would keep pressing these things. Make sure one, I always say showing up is more than half the battle when it comes to debt collection lawsuits. If you're being sued, one, showing up is filing the answer. I've talked about it before. 95% of people do not do that. But if there's hearings like this, just make sure you're there. Keep pressing your point of view. Keep pressing the case. If you're doing something, if the court's doing something that doesn't seem fair, if the shoe were on the other foot, would the court have entered judgment if you didn't show up or if you weren't prepared? Probably. I bring that up. I bring it up respectfully to the court. I've done it before. I've had judges where I've shown up for trial and the plaintiff's attorney is not there, or it's like been 30 minutes and they're really super late. And the judge will say, well, why don't we continue this, push this out to another date? And I'll say, hold up, judge. Respectfully, if my client didn't show, you would have entered judgment a long time ago. You would have done it immediately. And they always say, you're right. And so they'll enter judgment. So, Rob, I would just say keep doing what you're doing. It sounds like you're there. You're on top of it. You're focusing on what you need to do. I think you're going to have you say right here, they did have an attorney show up, but they didn't do anything. Same thing. Even if they're there, but the same thing, the fact that there was a trial date set and then the court just at last minute pushed it off, it all sounds a little bit sketchy as far as what's going on there, as far as procedurally. All right. Joe said, hi, John. In a prior podcast, I told you of a Citi card charge-off bought by Midland. Due to the age of the debt, that said they wouldn't sue, not couldn't. Since I am being contacted by Northland Group, who must be acting on the same debt because other accounts are being settled. Could they sue me? So the key here is if you think that a debt is outside of the statute of limitations, which we were talking about, I think, before, and we've talked about a lot here on the channel. If a creditor, the Fair Debt Collection Practices Act, the FDCPA, if a debt is too old, if it's outside the statute of limitations, then they are not, they have to actually write there on the letter that this debt is too old, so we're not going to sue you, but we're asking if you want to voluntarily pay it, that kind of thing. If you're not sure if that language isn't on the letters, if the creditor is maybe inferring that it's too old, the way you calculate it is, one, you have to know the statute of limitations in your particular state. If you're in the state of Arizona, on a credit card, it's 6 years. 6 years from the time the account goes into default, which is roughly 30 days after the last payment was made. They have 6 years to file the lawsuit against you. And if they don't file the lawsuit against you within that time, then they're barred from doing it. So you can Google statute of limitations, Nevada, Colorado, New York, whatever it is, statute of limitations, credit card, and you should be able to find that pretty easily. If you look through some of my videos in the comment section, I actually one time went through all 50 states and listed links to the statute of limitations. So you can go, I can maybe look for that later and find that. But so you need to go take a look at that, see exactly what your statute of limitations is, and then go back and look from 30 days after the last payment was made. If it's been longer than that, then you should be good to go. And you wouldn't, if the statute is expired, you don't want to pay it. Now, as I always have to bring up, there's a difference between the statute of limitations and the time that a civil judgment is valid. Statute of limitations only deals with before the lawsuit is filed. There are other statutes that deal with how long a civil judgment is valid. So I often get people here in my practice in Arizona that are always telling me, hey, there's this old judgment from 2005. Isn't it past the statute of limitations? Totally different thing. In Arizona, civil judgments are good for 10 years and can be renewed every 10 years for the rest of your life. So that's different than the ability to sue. If they've sued and the judgment's been entered, statute of limitations is likely off the table. All right, let's see what Amy has to say. Amy said, I filed a motion to compel arbitration. I got to get up. This is a big question. I got to get up over top of here. I see online that the plaintiff is asking the judge for it not to go to arbitration, even though it's in Citibank's contract. So now I got a notice to appear by Zoom call next week for a status meeting with the Superior Court judge. What are they going to ask me about a status, and how should I answer? Also, the only Superior Court judge is an acquaintance of mine, and I would rather not have him adjudicating. Okay. We'll go last things first here. If the judge is a friend or something like that, the judge, truthfully, I mean, because the judges, if they're dealing with a large volume, they may not even have seen it yet. But if they see it and they say, "Hey, I know Amy," they should recuse themselves. Depending on if you're like I don't know if this is Arizona. If it's Arizona, if it's a smaller county, there may not be a lot of other Superior Court judges, but they have what are called pro tems who can fill in for the judge if there is a conflict or something that could be perceived as a bias. You can also you can file a motion to have the judge changed, and you can put in there that, your acquaintance, your friends, your family, whatever it is. The judge should initiate that, but if they don't, you can request it. And if they don't request it before the Zoom hearing, you can even request it then. My guess is if you show up to the Zoom call next week, the judge may say, "Hey, I know this person." They're going to say, "Hey, I'm going to recuse myself," and you'll get a different judge. As far as what to expect at the what do you call it? As far as what to expect at a status conference, a status conference is exactly they're just looking to know the status. But the fact that you filed a motion to compel arbitration and that's out there, and the other side has really objected to it, you should expect to get questions on that. You should do exactly what you did here in the question and say, "Look, this is Citibank's contract. It says I can ask for arbitration." I would read that whole arbitration clause in the terms and conditions on the credit card, fully understand what it's saying there, look for any limitations as far as deadlines. Like usually it'll say you have to ask for arbitration before trial starts or something like that. Just say, "Judge, look, we're well within the time frame. This is the route I want to go." If the judge were to ask you why, there's a lot of reasons to go to arbitration. It's less formal. The procedural rules, particularly for self-represented people, if you're actually going to do an arbitration hearing, it's much more informal than going to court. The court, you're dealing with the rules of evidence, you're dealing with rules of procedure, things that non-attorneys are not used to and comfortable with. So it levels the playing field a bit to be in arbitration. So that's a good reason that you can tell the court, "Look, I would just prefer some of the informality that goes along with arbitration rather than what's going on here." You also can ask in arbitration for one arbitrator, 3 arbitrators. It's just a different process altogether. And so you nailed it. It's Citibank's contract. This isn't you just making something up. You're saying they said, "Hey, if you had this card, you can have arbitration." That's all you need to tell the judge. The status conferences, I know it's something that, especially if you're not used to it, you're going to get kind of nervous about it. If it's over Zoom, it'll be probably relatively short. And it may even end before it begins, because if the judge recognizes you, the judge may say, "Hey, this is not a case I can sit in on." So hopefully that's helpful. All right. Brooklyn says, "When it comes to bankruptcy, who do some attorneys recommend to stop paying debt before filing? And some say you can be current filing in regards to unsecured debts." Okay, so good question. Because I get this question a lot. Again, here in Arizona where I practice, people say, do I have to be behind on my debt to file? No, you don't. I file bankruptcy for a lot of people who are completely current on their credit card debt. They just know they've, one, been hanging on, by tips of their fingers, trying to hang on. And 2, they've been making the monthly payments, but they know they can't do it anymore. So you don't have to be behind on it. My recommendation to people, when they call me here, when I do a consultation, I say, "Look, if you have made mentally the decision 100%, I'm filing this bankruptcy, I would not pay any more money to credit cards, personal loans, medical bills. I wouldn't pay those anymore. It's not going to impact your overall credit. It's just going to be a waste of money. You're throwing the money away." Not only that, if you were to pay a big chunk to like a credit card and then file bankruptcy in less than 90 days, the bankruptcy trustee may go back and get those funds from that creditor as what's called a preference and distribute it out to all the other creditors evenly. So there's just no reason to continue to do that. Nothing's going to happen quickly. If you stop paying your credit cards, they have 6 months. They're going to do internal collections before they do anything like a lawsuit. So I would recommend, don't waste money. Focus on getting the bankruptcy filed and kind of moving on from there. So that's kind of the approach that I take. So Let's see here. Oh, Joe had a follow-up, said, I know the statute of limitations has not passed, which is why I'm confused why Midland said they won't sue me. Since Northland Group is now calling me, could they sue me? Now, you know what, let me look this up. I am 90% sure that Northland Group is not a debt buyer. They are a collection agency, is my recollection. Let me see here. I'm doing real-time. Maybe they do buy some debt. So see what I can find out. I know this isn't very good YouTube time, but we're going to find an answer here for you. Oh, okay. So I guess I didn't realize that. So Northland Group is also known as Radius Global Solutions, which is a debt buyer. So, you know, they may be, if Midland's saying they won't sue you, they could have something internally that's telling them, one, there's a problem with the case. They may not have documents. They may not have something that they need to be able to establish it. Or they may be interpreting the statute differently. Sometimes, like there's a statute in Arizona that says if the contract was entered into outside of the state of Arizona, statute of limitations is 4 years. So they may be there could be something like that in the state that you're in. So there's something wrong there, and it looks like they may have actually sold it to this Northland Group, which would be this Radius Global Solutions. Sometimes companies like that will just do collections, so they'll farm it out to there, but they may have transferred it again. And my general rule, the more times it changes hands, the better off you're going to be, the better chance you have to having that prevailing on that. All right. That guy from the thing says, I went to court today and the judge told me I'm not allowed to argue law because I'm not a lawyer. I cross-examined the witness and I tried to object to evidence due to her lack of personal knowledge. He overruled me and said I can't argue law because I'm not a lawyer. Have you heard of that? And what should I try to do next? Are you in America? I mean, really, if you can tell me what state you're in, that's bizarre. I've never heard that. Lawyers don't own the law. Judges don't own the law. You can argue the law. Of course you can. Self-representation is a right in every single state. Like in Arizona, if you're a corporation, corporations cannot represent themselves and LLCs can't represent themselves. But that's wrong, 100% wrong. And, you know, yeah, I'd be interested if you put that in the section, what state that's in, because that's un-American is what that is. And that's just wrong. So that would be, if the court ruled against you at trial, that would be a reason you could appeal it. And that would be overturned. That's abuse of discretion by the judge. I mean, to say that you can't argue law is wrong. Attorneys are wrong on the law all day long. So, okay. So you're saying you're in Virginia. I don't know about you East Coast folks. But yeah, so that's a basis for appeal. I mean, to say that you can't argue law. Maybe Virginia, you're more, I don't know, highbrow than we are out here in the desert in Arizona. But you can represent yourself and you can argue the law. That's just, it's ridiculous. So, all right, let's see here. Amy had a follow-up. First answer helped, but in a status meeting, will they ask guilty or not while I'm fighting the charge? First, just a quick terminology thing. In civil cases, there's no guilty or not guilty. It's just liable or not liable. Okay, so you're saying you are in Arizona, in Apache City. Okay, so it's just whether you're liable or not liable for the debt. They won't go into that. The judge will not ask you that. They won't say, hey, well, you owe it, right? They're not going to say that. But who knows? In Virginia, they're not even letting people talk about the law. So I guess it could happen. But no, they're not going to ask you about that. That's not even relevant to what's going on here. The whole thing is that their contract says that you can take it out of one forum and put it into the arbitration forum. That's all you're asking. The underlying merits don't matter. This is a procedural thing, and you should be able to do that. So, all right, let's see here. Mary says, can they sue you if the original creditor stated they would not sue? I mean, it depends on who's saying it. If it's a letter like we were talking about and it's outside the statute of limitations, then that could be used to your benefit. If you were just talking to like some customer service person and said, hey, we're not going to sue you, then no. I don't think that that's going to that won't hold up. They'll be able to still pursue their rights on that. So, all right. I think that will probably do it for tonight. We've got a solid 20 minutes in there. But hey, yeah, guys, I said check out some of our other videos. You know, we have a ton. I was looking. I have over 800 videos on the channel, and I've probably talked about every question 1,000 times within those different videos. So go back and look at those. If you have any additional questions, put them in the chat. I do go back and take a look at those. Check out the folks over at Solo Suit. They do a wonderful job of helping support us each and every week. And with that, I'll catch you next week.